Hello class, my name is Catherine Keelis and today I'm going to be discussing case 4, which is the case between Ricci and DeStefano. So first I'm just going to be explaining what the case is about. So the case is a labor law case of the United States Supreme Court on unlawful discrimination to disparate impact under the Civil Rights Act of 1964. So plaintiffs, both white and Hispanics from the New Haven Fire Department, sued various city officials in the United States District Court for the District of Connecticut when the New Haven Service Board failed to certify 2 exams needed for the plaintiff's promotion to lieutenant and captain. In 2003, about 100 or more New Haven firefighters took examinations to qualify for promotion to the rank of lieutenant or captain. The written exams were to account for 60% of the ultimate assessment of a candidate's ability to successfully serve as a lieutenant or captain. 40% of an individual's assessment consisted of an oral exam evaluating a candidate's ability to lead others in emergency situations. When the results of the exam showed that white candidates had outperformed minority candidates, a public debate was issued. Some firefighters argued that the test should be discarded because the results showed that the tests were discriminatory. They threatened a discrimination lawsuit if the city made promotions based on those tests, while other firefighters said the exams were neutral and fair. And they in turn threatened a discrimination lawsuit if the city ignored the test results and denied promotions to the candidates who had performed well. New Haven City Charter requires that the Board of Fire Commissioners use civil service examinations based on a rule of 3, where only the top 3 highest scoring candidates on each of the lieutenant and captain exams may be awarded a promotion. Under this rule of 3, no African American candidates could be awarded a promotion based on the test, since none of the top 3 highest scores on either test belonged to an African American. But the CSB did not certify because the results of the test would have promoted a disproportionate number of white candidates in comparison to minority candidates. So New Haven representatives argued that when measured against the EEOC's 4th-5th standard, a presumption that the test resulted in disparate impact discrimination was inevitable. The plaintiffs, which are the 17 white male candidates and 2 Hispanic male candidates, argue that their rights under Title VII of the Civil Rights Act of 1964, 42 U.S.C. Section 2000E, and the 14th Amendment and the Equal Protection Clause were violated. Plaintiffs were unfairly kept from job promotions because of their race and were expected to have widespread ramifications for affirmative action in civil rights law. So now we're kind of just going to get into what is the issue here, because I know it was a lot. So basically the issue is whether city officials is trying to diversify a civil service department and whether they are guilty of racial discrimination under the Equal Protection Clause or of Title VII when they decide not to utilize written test results which favor one racial class over another, and whether an employer violates 42 U.S.C. and 2000E, which makes it illegal to adjust test scores or cut off scores based on race, when he decides not to utilize test results because the successful candidates are all of one race. So now the question is, what is the specific federal law or statute being litigated? So, Title VII of the Civil Rights Act of 1964 is a specific federal law that Ricci and the other plaintiffs are fighting. Under this law prohibits employment discrimination based on race, color, religion, sex, and national origin. Under the Title VII of the Civil Rights Act, an employer may not discriminate with regard to any term, condition, or privilege of employment. They are also arguing the Equal Protection Clause, which requires states to practice equal protection. Equal protection forces the state to govern impartially, not draw distinctions between individuals solely on differences that are irrelevant to a legitimate governmental objective. They are also fighting that city officials are violating their First Amendment rights. The First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. Based on all of the specific federal laws that they are fighting, the Title VII of the Civil Rights Act is what the Supreme Court held that by discarding the exam, the city of New Haven violated that title. We will talk more about this in a few minutes. I did want to talk about what is the protected class that is involved in this case. So, if you guys didn't know, a protected class are groups protected by law, which include men and women on the basis of sex, any group which shares a common race, religion, color, or national origin. These type of groups are protected from the employment discrimination by law. In this particular case, the protected class involved are the 2 Hispanic candidates and the 17 white male candidates who were all denied opportunities for promotion because of their race. So now we're going to talk about a little of how far did the case progress through the court system. So in order for a case to even go to the Supreme Court, and it went all the way to the Supreme Court, it has to go through a couple things first. And so we're just going to discuss what it went through. So first off, city officials referred the issue of the test results to New Haven Civil Service Board. So the board are the people who are responsible for overseeing New Haven civil service examinations and assessing results before certifying eligible candidates for promotion. The board held various public hearings to determine whether they would certify a list of eligible candidates. So the board heard evidence regarding the test results' disparate and adverse impact on African Americans. However, the board did not know whether to certify the results, so they decided to not certify any list of eligible candidates. Frank Ricci and the other firefighters who were among the top scorers and thus they were eligible for immediate promotion, they then decided to sue New Haven's mayor, John DeStefano, and other city officials under Title VII of the Civil Rights Act of 1964, alleging violation of the Equal Protection Clause. Now we're going to discuss how it all went down. So first, Judge Janet Bonds in the Federal District Court, so the plaintiff and the other firefighters took this case to the District Court, and the Federal District Court ruled for the city, granting its motion for summary judgment, dismissing Ricci's Title number 7 and equal protection claims. So the firefighters, obviously they lost in the U.S. District Court. The district judge relied on EEOC guidelines, noting that the 4/5 rule would generally be regarded by the federal enforcement agencies as evidence of adverse impact. This judge also explained how New Haven had no obligation to have the test validated after the fact, noting that EEOC guidelines, and this is a quote from the judge, stating that EEOC guidelines do not require or mandate a validity study where an employer decided against using a certain selection procedure that manifests this disparate impact. And Ricci's argument that DeStefano violated Title VII by refusing to conduct a validity study before rejecting testing results is unpersuasive. So basically, in other words, the district court claims that the Civil Service Board acted because of the apparent discrimination against black promotional applicants, not to intentionally discriminate against white promotional applicants. In short, the plaintiff disagreed with the judge's ruling and appealed to the Court of Appeals. So in order to have your case appealed to the Court of Appeals, you must follow a few steps before that. So Ricci and the other plaintiffs must prove first that they are part of a protected class, which they are, qualification for the position, they have to prove an adverse employment action, they have to prove circumstances giving rise to an adherence of discrimination on the basis of membership in the protected class. Once they prove all of this, they can move on to the Court of Appeals. So, on appeal, a 3-judge panel of the Second Circuit Court of Appeals heard arguments in this case of discrimination. However, in a 7-6 decision, the Court of Appeals affirmed that the district court's ruling in a summary order without opinion on February 15, 2008 were denied. And they were also denied a rehearing as well. So basically, the Court of Appeals sided with the Federal District Court's rulings. They didn't stop there, though. Ricci and his fellow plaintiffs didn't think it was fair, so they took their case to the U.S. Supreme Court, and they agreed to hear it. The Supreme Court granted on the consolidated cases on January 9, 2009. So basically, the Supreme Court explained that in a situation like that of New Haven, an employer doesn't have to demonstrate intentional discrimination, but must have stronger evidence than the 4/5 rule presumption of disparate impact. Also, the judge that was on that case, which is Judge Kennedy, noted, and this is his words, that reconciling the interests of those who do not pass the test with the interests of those who should require employers to act with extraordinary care, and that it should take a strong basis and evidence to support race-based remedial actions. On June 29, 2009, in a 5-4 decision, the Supreme Court found in favor of Ricci. The majority held that, in discarding the exams, the city had violated Title VII of the Civil Rights Act of 1964. So in summary, the Supreme Court held that the city improperly discarded the examination to achieve a more desirable racial distribution of promotion-eligible candidates, since there was no strong basis in evidence that the examination was deficient and that discarding the examination was necessary to avoid disparate impact. So who won the case? Well, I kind of just stated it. The plaintiffs and the other firefighters won the case. The Supreme Court ruled in their favor. I was trying to find what they won and what did they get, or if they were awarded any settlements, but I really couldn't find anything about that. I also couldn't find if the employer had to do anything. I couldn't find anything about that. However, I did find that a settlement was reached in which the City of New Haven initiated efforts to increase minority representation in the New Haven Fire Department and to conduct examinations in a fair manner that comply with Civil Act rights. So now the question, after I've explained the case, the question is, what is the significance of this case? What should employers know about the case, and how does it impact human resource management? That's a good question. So the Ricci versus DeStefano kind of highlights the difficulty that employers can face in trying to achieve a diversified workforce while refraining from discrimination against traditionally advantaged groups. So New Haven arguably was trying to avoid Title VII liability from African Americans who may have alleged that they had been denied promotions based on a test that had disparate impact, but instead violated white candidates on their Title VII rights. So basically, New Haven was trying to diversify their workforce by giving African Americans promotions to have a more diversified workforce. But instead, they kind of took the opportunity away from white candidates who were perfectly qualified and who proved that they qualified for the position. The significance of this case was also to fight disparate impact. The court suggests that if a test is designed to be race neutral, the fact that the numbers come out differently than an employer expects is not, in of itself, enough to throw out the results of the test. Moreover, it teaches employers to tread cautiously in conducting a disparate impact analysis for layoffs and terminations, as well as to remain biased and fair when conducting examinations. That is really important. The outcome of this case may provide employers with some guidance as to also how to achieve racial diversity in the workplace while avoiding these types of lawsuits. The court's decision, which agreed that the plaintiffs were unfairly kept from job promotions because of their race, was expected to have widespread ramifications. This case not only impacts human resource management in the sense that it violates employee protection laws. Human resources is all about protecting employee laws. It's all about how are employees protected by their job or by the company. So this case clearly violated the Title VII Act of the Civil Rights Act of 1964 by discriminating on white and Hispanic males in order to promote minority groups. So basically, the plaintiffs, Ricci and the other firefighters, were suing for reverse discrimination. Employees legally have the right to protect themselves from such actions that these firefighters received. And that is my presentation, and have a good day.